Roland Mumford with Mumford.law. I've done a couple of videos here previously about WhistlinDiesel, the famous YouTuber with over 10 million subscribers who was recently arrested and charged with a felony for sales tax evasion here in the state of Tennessee. And in fact, it was Cody Detwiler, that's his name individually, and WhistlinDiesel LLC that were subject to, in the indictment, to 2 counts of tax evasion. Count 1 was against Cody Shane Detwiler, and the second count was against WhistlinDiesel LLC. That was from the Circuit Court of Williamson County. And the case number on that, if you want to look it up, is 25 CR 19387. Now, it's the state of Tennessee versus Cody Shane Detwiler doing business as WhistlinDiesel LLC. So everybody knows that this issue about the burned up Ferrari in Texas. And did he try to avoid sales tax by purchasing the Ferrari through an LLC in Montana? Something that's been going on for years and thousands of people have done. We did that second video to show how broad this occurs and how many luxury vehicles are registered with a Montana license plate, but they're located in the owner's primary state of residence. And so anyways, the main issue about this video is something that really perturbed me, and is that the prosecutor in Williamson County filed a motion for a gag order. And I am a Section 1983 civil rights attorney, and a good bulk of the cases that I have involve free speech, whereas maybe I'm representing YouTubers who were falsely arrested because of retaliation by police officers, because those YouTubers were doing videos on those officers, or maybe they were doing investigations into corruption of the local government. I represent 2 teachers in South Georgia against the county that didn't hire them because of online content posted, retaliation. And I represent a number of other people in different forms of free speech retaliation. So this is something, when I first heard this, when I first watched Cody Detwiler's updated video about this motion for a gag order, I think I used every expletive here in my home, and I was so determined to do this video. The motion hearing was this morning, and I'm trying to get more information about what occurred, but the local newspaper here has the article behind a paywall, and I'm trying to get some information through some local sources. But it appears that any gag order that was issued today was limited. But what is ridiculous about the gag order, and we're going to talk about it, I'm going to play a video here from Cody Detwiler from his channel where he talks about the motion for the gag order and his take on it. And then I'm going to throw up the actual motion for the gag order up on the screen, and we're going to go through it. And then we're going to talk about the applicable Carruthers case. That's the Tennessee case, the issue of free speech and gag orders being put upon criminal defendants. And that was a case that involved murders, threatening of witnesses and other parties. And even there, the court said that while it upheld the gag order, it said that the terms of the gag order was overly broad. So this was absolutely ridiculous that this local prosecutor in Williamson County, Tennessee, filed this motion for a gag order. And then as I started going through the motion, there's very limited precedent cited in the motion. There's hardly any legal argument. And what is crazy is that the state of Tennessee arrested Cody Detwiler at his house, and from the updated video that we're about to play in a second from Cody, he talks about how his accountant had been contacted a year before. The state has been working this case up for a year or more, and they intentionally arrested him knowing that this was all going to be public. So the state of Tennessee, the Department of Revenue, and the local prosecutor, they created this vortex of public controversy. They entered into the controversy. They entered into this vortex of public controversy. And I intentionally use that phrase, vortex of public controversy, because that is the exact language that is used in other free speech cases, particularly, for example, in New York Times versus Sullivan and other cases where it differentiates whether you're a public figure or not a public figure. And when you're a person that creates or you participate in a matter of public controversy, then you can't really complain about then wanting a gag order. Is kind of the point I'm trying to make. So here, the state of Tennessee, the Department of Public Revenue, and this local prosecutor, they intentionally are doing this to make an example out of Cody Detwiler so that thousands of other people in Tennessee will stop purchasing vehicles out of state through an LLC to avoid sales tax. They're trying to make an example out of him. And I believe one of the issues of the criminal defense attorneys, and I know the two names that they hired who are excellent criminal defense attorneys, they are going to hopefully maybe make the argument of, well, how many other people before this did you send a notice to and give them the opportunity to pay the sales tax or the penalty without arresting them? And here, why are you arresting him, making an example out of him? I think it is improper discretion on the part of the prosecutor. Whether you want to argue that this is prosecutorial misconduct, I think you could have that debate. But to arrest somebody, to intentionally make an example out of him, knowing it's going to be all over the internet, millions and millions of views, but then you contradict yourself and then you file a motion for a gag order and complaining about the very intention, the vortex of public controversy that you created, Mr. Prosecutor, Department of Revenue. You started all this controversy, which could have been resolved with discretion, and he may have just paid the thing off because it wasn't worth his time. You created this controversy, and then you have the nerve to file a motion to shut him up, to say that he can't talk about it. And we're going to talk about more in detail how you complained about how he's trying to make money off of the mugshot and the indictment, which I thought was hilarious because you guys made that public. Let's talk about this here on the other side of this video by Cody Detwiler, where he gives his take on things. And then we're going to go through the motion and we're going to read it, this gag order. And then we're going to do, at the end of the video, we're going to look at the Carruthers case and talk about the elements of prior restraints, what gag orders are, and what the law is on it as it applies to participants in a criminal case, whether you're the attorney, a witness, or the defendant. See you on the other side.
Okay, I am making this video to discuss two major updates regarding the reason I was arrested by 5 police officers at my front door and jailed several days ago. So obviously this was a big surprise to me. I had no clue what any of this was for, as I said in my last video, and I made that video as an update to give you guys transparency. Obviously, my mugshot is on the internet. I've never been arrested before. I have a clean criminal record. And I think the public deserves to know why, right? That is something that you would think would be deserved, the freedom of speech. That's why it was quite surprising to me that after making that video, I got not only this investigative report related to the tax evasion, the alleged tax evasion, but also a gag order to stop talking about it, which you would think would violate my First Amendment right. I had no clue that existed. I didn't know what a gag order was, so I did some research. Basically, it would say that if this goes through, which I have court for on Monday, not even the tax evasion thing, the gag order, if this were to go through on Monday, I would not be able to say anything at all about this case. No videos, no updates. I cannot talk about it. So I want to talk about this gag order because it's very interesting. Not as interesting as this report, which we're about to talk about too. So I want to make this video out of transparency to show you guys what is going on in the government, what they're allowed to do anyways, factually what is going on in my life. This is just an update for the thing they're trying to put me in prison for. So in this gag order, they list my influence. I have 20 million combined followers. It says the gag order would prohibit me from making any pretrial extrajudicial statement via any form of social media platform. So they show all my social media posts, me saying I'm going to take the killdozer to court. They show my Instagram posts. They show my story posts. They show just me covering what happened. And then, referencing the YouTube video I made, they got over 6 million views. And obviously that made it to the top pretty quick because a lot of people saw how absurd the case was, and people up there heard about it from those people. It says, based upon the foregoing, the state moves this court to enter a gag order against the defendant, applicable to any and all of his social media platforms, prohibiting him from commenting on the case or its fact pattern in any fashion, and from attempting to monetize the prosecution in any form. His actions threaten the ability of the state to prosecute the case fairly and without outside influence, and potentially threaten the safety of those involved in the prosecution. So number one, I don't think anyone here is a threat. I think people are just confused and a little angry. People are rightfully angry. If they came to my door for something this absurd, they're not stopping there. They've shown what they are willing to do. And what I'm about to reveal in this gets a lot more dirty. Then, of course, they emphasize that they would prohibit me from attempting to monetize the case in any form. So on this page, they have a screenshot of my merch for sale. You know what my merch has on it, which thank you guys for buying it. That actually, my legal fees are still more than what sold in merch. But you know what my merch has on it is the public indictment page that they posted when someone gets arrested. Anybody can access this. It was already public. All I did was draw a lot more attention to it. So that has, it's public. It has names on it, and mostly Department of Revenue who is responsible for this. So the fact that my First Amendment right is being tampered with is insane. Like, that's actually insane. I did not know that a gag order was possible. And so I have court for that on Monday, before this whole thing. That just shows how much this whole thing is going to blow up. So I don't know if they poked the wrong hornet's nest, or everybody was assuming they might try to make an example out of me. Like, I would assume they knew that like, I'm going to make content on this. So I think the reason they want me to stop talking about all this is that my influence is so big. They state all my followers and everything, and my influence on social media, that I could, basically everyone could side with me, and I could bias the jury, and it wouldn't make a fair trial for me against the government, for me against the state government. It wouldn't be fair. It wouldn't be fair for them. So they want me to stop talking about it. Now, I agree, it's not fair for anyone to threaten anyone. Please don't threaten anyone, but it's totally okay. You have the freedom of speech as well to ask the Department of Revenue why they are doing this. So it is cool. I'm legally allowed to talk about all this until Monday, if that were to go through, which is going to be quite difficult considering I very much so value my First Amendment right. So that was my First Amendment right. And right here, I have a many-page long investigative report on all the details of this case. Now, I can't say I was too surprised when I read this because a lot of it made sense, but I did laugh when I was reading it. I don't know about you guys, and this isn't me defending myself, but that is wild. So they wanted me to not know. That just shows me that this was not about the money. This was never about the money. This was not about $27,000. This was about sending a message. So I don't know if they targeted this and chose me on purpose because they thought it would get the word out that, oh, they're collecting tax. You better move your registrations to Tennessee. I think they picked the wrong guy for that, because even though it was public when it happened, it's going to be a lot more public now. I find it so wild that instead of informing me of how to be compliant over a year ago and collecting the tax, they decided to do all of this, arrest me and take me to jail and progress this whole case, which I looked up the punishment for. You know what some of the max punishment for tax evasion on this is? 1 to 6 years in prison. Let me ask you guys a question for the viewers watching this. I don't know code A2-610C9324A9 or the tax code. I don't, frankly. I take the advice of the people around me and maybe business advisors and people who I trust and friends who I talk to, and I put together the best plan that I think is to run a business. And I think everybody in the United States wants to file their taxes appropriately. Like, everybody knows, okay, pay your taxes or you're going to get arrested. That's obvious. But when there's no information or education provided on it, and you are simply, your first move is to build a case and arrest those people, the trust in the government is lost. It is 100% lost. If they stopped with, if they did this to me, they're not stopping with me. This is going to happen to other people. This just shows what they will do. These two things, this is what I wanted to talk about. If you get anything out of this video, it is that they say I owed tax, but they would not tell me, and they would not tell me what I owed, and they would not educate me on what was owed or inform me about it. And they also want to take away, tamper with, I guess, my First Amendment right. That's wild. And just so you guys know, if you owe money to the IRS, they send you a letter. They say, hey, you owe this amount. You have this amount of time to pay it. Thank you. I really appreciate that. And I get mail at my address, which is exactly why I was so confused about all of this. I was like, if, God forsaken, I got super sick and couldn't check my mail or something happened, I'm on a long vacation. I was like, if I owe tax and I don't know about it or I did something wrong, I will get a letter or a notification and they're going to tell me and I can be in compliance. I know this, right? Yeah, I was very surprised. I did not find any of this information. I got these documents a week and a half or 2 weeks now. No, it's been minimum 2 weeks after this arrest that I got these documents to see all of this. It reassured what I kind of thought, because I was like, I never got a notification. You know what I think it is? I think they started this whole mess to make a statement. And then when they realized that they messed up, they have this to shut me up because they don't want people knowing about all of this. What did they think would happen? Rightfully so, everyone's frustrated. Maybe I've said this already. I hate the fact that it looks like I'm defending myself, right? Because who wouldn't? Who wouldn't defend themselves against, some sort of legal issue, right? I get it. I don't want to sound conceited in this. I'd rather not be making this video, frankly, though. I think most of the public thinks that if the government says they did something wrong on their taxes, they're going to get a notice or a notification or a letter. Apparently, that's not always true. I'm not a tax expert. I take the advice of friends and family and people around me, and I try to do the best I can to have a good business and, have a good life. People at the state want to collect sales tax, and they probably wanted to send a message, and they were like, what better person to use as an example than this guy that destroys Ferraris? Which this was an accident, by the way. I just like to have fun. I'm a random Joe Schmo. As much as what I do looks crazy, there's a lot of times my bank account's still zero. I reinvest just enough to do what I want to do. My goal in life is experiences, not money. Even though I think it's amazing to have a cool car and a lot of cool things, those things end up destroyed because I have fun with them. Like, what I want is an experience. I think they saw me as some sort of easy target. I guess maybe they haven't seen how we handle that. Like, my goal throughout everything I do in my business is to be squeaky clean. I want to be in compliance with the law. Like, I wouldn't put all the work and effort and improvement and investments into my business if I was just going to risk it all for some stupid legal issue. Like, my goal is to be in compliance. I don't want to cause problems. What I do looks crazy, but I try to be in compliance with everything I do. This whole case has just been wild. I really appreciate everyone's support, genuinely. I just did a podcast with Cameron Haynes about this yesterday, good friend of mine, and I went to Tucker Carlson's Christmas party. There's a lot of people that I really appreciate their support very, very much. Genuinely, thank you so much. I did not expect the people coming out of the woodwork for this. This just feels so absurd for $27,000, and I wasn't even notified of how to be in compliance. Thank you everyone who's been buying the merch. I actually upgraded the quality because it was a little lower than what I would have liked. There's still that no tax if you don't want to pay the sales tax on that. I'll pay it, state of Tennessee, don't worry. I'll cover that. It won't be much though because the prices are fairly cheap. So I really appreciate your support, guys. I thought if everybody else could leave, all the 10 million people watching, and we'll just leave the Department of Revenue a message for you guys. So I understand your goal is to collect sales tax. I get it, that's your job. My job is to talk about you collecting the sales tax in this case. So I get we're at a little bit of a stalemate. I would prefer to not make these videos. I'm just being transparent with the public because this is America. They deserve to know what's going on with me when they see my mugshot online, and they deserve to know what's going on in the government. So America is for the people, and the people are the ones in charge. I don't have anything against you guys personally. I haven't seen your faces. I'm sure you're great people, and I know your job is to collect tax, but what better way to collect tax than to educate people on how to be in compliance? The pissing match does not work. America was founded by real people that value and protect freedoms, and I'm one of those people. If we want to keep playing this game, game on. If we can have a meeting and talk about this and figure out a way to educate people on what your guys' goal is, game on as well. I would love to work together, but just as the same reason my mugshot was public when I was arrested with 5 cops at my door, the public deserves to know why. And that's why I've made this video. So thank you everyone for watching. Once again, I will give you updates regularly as I have them. If the updates stop coming, it may be related to the gag order, although I think that's not going to, for number one, I don't think it's going to happen. And number two, I think it will have little effect regardless. Also, another thing, everyone, please, everything regarding this entire case, if you guys have a role in any form, whether that's physical, if you are showing up to the courthouse, or if there's any communication to anyone in the Department of Revenue, just please be respectful. It's okay, it's your human right to communicate and to show your voice. Just please be respectful. Don't threaten anyone. We want to be safe and mature adults and deliver a message properly. I know my followers are respectful. We want to be the bigger person. So just please be respectful. Thank you everyone for your support, and I'll keep you updated.
Let's take a look at the indictment before we take a look at the motion for the gag order. This is the state of Tennessee versus Cody Detwiler, doing business as WhistlinDiesel LLC. This is out of the Williamson County Circuit Court. You see the case number. Indictment for tax evasion. The witness summons for the state, and it says Curtis Ritchie, Tennessee Department of Revenue. Carlin Hess is the prosecutor. The indictment was returned November 5th, 2025. State of Tennessee, Williamson County Circuit Court, got count 1 tax evasion. The grand jurors impaneled present that Cody Detwiler on or about January 3rd, 2023, before the finding of this presentment, did unlawfully and willfully attempt in any manner to evade or defeat any tax due the state of Tennessee in an amount of $500 or more, sales tax due to the purchase of a 2020 Ferrari F8 Tributo in violation of TCA 67-1-1440G, a Class E felony, and against the peace and dignity of the state of Tennessee. And then count 2 for tax evasion against WhistlinDiesel LLC in the exact same language that we just discussed. All right, let's now take a look at the motion for the gag order. All right, this is the state's motion to impose gag order on defendant. And it has been confirmed to me that the defendant did not file a response, that the attorneys for Cody Detwiler did not file a response to this motion, probably because this motion was so absurd that it was fatal upon its filing. Because the motion lacks any serious legal argument, any memorandum of law to support the relief for which it's seeking to obtain. And the Carruthers case that it's relying upon was already held by the court that it was overly broad, and that involved a case, a criminal defendant, where witnesses had been intimidated, threatened, prosecutors apparently had been threatened, and that involved a murder case. And even there, the court said the gag order was overly broad, but it upheld the basics of it, but it said it was overly broad. I think the prosecutor knew that this motion was never going to be upheld. So let's talk about it. State's motion to impose gag order on defendant. It goes into identifying who the parties are, who the district attorney is. And now let's talk about the background. It says that the defendant, Cody Shane Detwiler, under the pseudonym WhistlinDiesel, is a popular social media influencer. And according to online social media sites, compiles users' social media presence. WhistlinDiesel has approximately 10.2 million subscribers on YouTube, 5.5 million followers on Instagram, 2.8 million followers on TikTok, and 6.6 million followers on Facebook. Now, essentially, they're saying here that the defendant's influence, status, and online popularity revolve around his obtaining valuable and exotic automobiles and either dramatically modifying the vehicles in outlandish ways, outright destroying vehicles in outlandish ways, or a combination of both, because that's what's obviously happened with the Ferrari. Now here, the Ferrari that is the subject of the instant indictment against the defendant, for which he's been charged with felony tax evasion, was driven through a cornfield in the state of Texas until it caught fire and was destroyed. Now, the YouTube video of this daring escapade has amassed 16 million views as of the date of this filing. Now, what they're trying to do here, obviously, in the motion, is they're trying to establish how many users he has, the power of his influence, how many views this Ferrari got, and to support his basis for the gag order and to shut him up, to establish a prior restraint that he not be able to exercise his free speech as a defendant in a criminal case and defend himself. And again, as I stated, the prosecutor initiated this public controversy. They intentionally arrested him, knowing it was going to be all over the internet. And then they complain about now him responding and saying that he is going to try to corrupt a potential jury pool and getting all this attention. Well, they created this attention. And that is the very hypocrisy about this that really perturbed me and motivated me to do this video. All right. So it goes into the indictment on November 5th, 2025. A Williamson County grand jury returned a 2-count indictment against the defendant in count 1 and count 2 for felony tax evasion in violation of Tennessee Code annotated section 67-11440. He was arrested on November 7th, 2025. We've all seen that video. And again, the jerk who put him into the cuffs and tightened them the way he did, that was so unnecessary. There was no resistance whatsoever. Now, let's talk about, this is where they start to complain and where the hypocrisy begins. The defendant's social media presence post-indictment. Now, since the defendant's arrest on this indictment, at Capias on November 7th, 2025, he has posted about the instant case numerous times via his social media accounts. On November 3rd, 2025, the defendant posted a 7-picture Instagram post showing his mugshot in arrest with the caption, quote, "One so big they thought I was cheating," end quote. Now, again, the hypocrisy of this is they arrested him. They knew this was going to get attention. Of course, he's going to talk about it. But then the very screenshot that they show right here about his mugshot, about his post, this was already online. This was already introduced into the public domain by the prosecutors, by the sheriff's department, by the local authorities. Anybody could have seen this online. I mean, how hypocritical is that? You go and post the mugshot or allow it to be put online as a public record, give it to the media, and then you complain about him putting it on a t-shirt and trying to make some money on it to pay his legal fees. I mean, I know narcissism. Trust me. This is narcissism. Then they show that this screenshot here shows him being put into handcuffs. Well, what did they expect? All this was also on body camera video. The body camera video is public record. Now, here they say on November 14th, 2025, the defendant posted the following on Instagram. Again, all this is being captured on their body camera video, which is public record. And they knew he was a YouTuber. They knew the individuals there had cameras. The police, as far as I know, never told them to do anything with the cameras. Didn't tell his I guess YouTube production staff not to follow them as they were walking from his large building there and down the driveway to where the police cars were. I didn't see anything in the video where they told him not to do that. But then here they complain about him posting about it. The arrest is public record also. Of course, he's going to talk about what happened to him and stand up for himself. And on November 16th, 2025, the defendant posted an Instagram story commenting on the details of the case, along with thinly veiled threats of unknown meaning. What threats? Let's take a look at this. Breaking this entire thing is about registering my Ferrari F8 in Montana. What is threatening about that? Do not move your Montana registrations to Tennessee. What is threatening about that? This is exactly what they want and why they're trying to go after me. They think it will make a wave through the luxury car community and bring in tax money. He says here, it just so happens they went after the first person to try to make an example out of. This will be the most enormous backfiring in history. What is threatening about that? It's very clear when he's talking about the enormous backfiring that he's going to stand up for himself, that there's going to be a public outcry, and that he's going to make fools of the Department of Revenue and the local prosecutor. That's what he's talking about. There's nothing threatening here. What do you expect? Now, also on November 16th, 2025, the defendant posted an Instagram video alerting his followers that he planned to bring his killdozer, pictured below, to his arraignment court date on Wednesday, November 19th, 2025, and drive it to the Williamson County Judicial Center. Needless to say, this created some consternation in the ranks of the police department. Thankfully, he did not drive his killdozer to the court. They're trying to use some inflammatory language here about the phrase killdozer. Anybody knows that's watched his channel that the killdozer is just a phrase. It's just a brand that he put on this very, very large Caterpillar or whatever brand bulldozer. Then he puts this armor kind of metal all over it and he uses to make videos. The word kill here is being overly sensationalized, very hyperbolic in the motion. He says, I'm taking the killdozer to court. And then here's a picture of it. Would I have advised him if he was my client to do this? Probably would have told him not to say this, don't do this. But common sense and any level of reasonableness would know what he meant by the killdozer and that there was nothing threatening about it. Now, furthermore, as of this filing, the defendant on his WhistlinDiesel.com website is selling T-shirts and hoodies containing pictures of his mugshot and a copy of this indictment in this case. The indictment and thus the T-shirts and hoodies contain both the investigator's name and the undersigned prosecutor's name. Well, it's public record, and the indictment was put all over the internet. It's a public document. These are public figures. You created this public document, and he put it on a T-shirt to sell. Does that sound a little familiar? Remember a mugshot? President Trump? Nobody had a problem with that. Again, the prosecution, the Department of Revenue created this controversy. He now is incurring very expensive legal bills. I know who these attorneys are. They're excellent, notable defense attorneys, and they're not cheap. We got the tax evasion hoodie. Finally, of great concern, on November 23rd, 2025, the district attorney's wife, a private citizen with no involvement in this case, received the following text message on her personal unlisted phone number. It has in the screenshot, it shows the first page of the indictment. And then somebody said, the hell is this petty ass bullshit about? What is threatening about that? Now, whoever sent this message, I'm pretty sure that Cody Detwiler had nothing to do with this. He's already said online, exercise your free speech, but do so in a professional manner. Don't do anything that is unlawful or unethical, that would incite anything dangerous or unreasonable, riot, etc. Don't do anything inappropriate. He has said that on his video. Exercise your free speech in a responsible, professional, and legal manner, which is what I always say. And he can't control whoever this person is, whoever sent this. But it doesn't say anything threatening. Is it harassing by whoever sent this? Perhaps. But I don't know if this person knows who this lady is. Have they talked before? I can't really give any more comment on that. But there's nothing threatening about it. Further, the state would emphasize that the above pictured screenshots only capture pictorial representations of the defendant's social media posts. Most of these posts contain minute-long videos of the defendant pontificating on the merits of the case, almost all of which contain both factual and legal misstatements, calling out the investigator by name, conspiracy theories as to justifications for the government bringing charges, and a slew of attention-grabbing non sequiturs that deserve no purpose but to inflame the passion of his followers. No, you're a hypocrite, whoever typed this. You started this. You knew he was going to defend himself. And how many people have been allowed the opportunity of a notice if there was some kind of sales tax deficiency that you let them pay it? You intentionally created this controversy to make an example out of it. And now, again, I'm calling out your hypocrisy. Now, let's talk about the gag order. In criminal cases, a court is justified in imposing a gag order against a trial participant, quote, when the trial court determines that those extrajudicial comments pose a likelihood of prejudicing a fair trial. State v. Carruthers, the case we're going to talk about here in a moment. These prosecutors knew they were going to lose this motion because if anybody reads that case, you don't have to be a lawyer to understand that the court, again, held that case, while the gag order was upheld, the court stated that it was overly broad, and that case was of such an extreme nature, actually involving violence, where the criminal defendant was engaged in some type of threats or actual violence towards others. Here, Cody Detwiler clearly didn't threaten anybody. And for them to go into court using this case as the reference for this ridiculous motion is absurd. Clearly, the defendant's extrajudicial statements, where we're reading the pleading, via his social media platform, serve no legitimate purpose other than to inflame the passions of his large following. The defendant's posts, posted without the defendant or his lawyer even having received the discovery materials in this case, expose the defendant's legal and factual misunderstanding of the case against him, poisoning potential jurors with misinformation that serves no purpose but to rile up his volatile fan base. Well, we could argue, Mr. Prosecutor, what was the purpose of you trying to make a public example out of him with his arrest, where you gave him no notice to pay the sales tax deficiency if he in fact was obligated to pay it? Don't be a hypocrite. Even more concerning is the effect of these posts on the parties that represent the criminal prosecution of the defendant. The undersigned prosecutor's wife receiving unsolicited and vaguely threatening text messages to her unlisted personal phone number demonstrates the wide-reaching influence of the defendant's social media presence and the resulting vitriol that can manifest among his followers. This is unacceptable on many levels and threatens not only the sanctity of the prosecution, but the safety of the parties involved. You could argue that somebody would have received that text message even if Cody Detwiler had not said anything online. You guys made this arrest public. You knew when you arrested a YouTuber with 10 million or more YouTube subscribers, and then the other several million on his other platforms, you knew this was going to be viral, that it was going to go national. In fact, it went global. It was on the Times of India website. And then you complain about the notoriety that he's bringing to defending himself. Based upon the foregoing, the state court moves to enter a gag order against the defendant applicable to and any all of his social media platforms. And this is the relief they're seeking. They want to prohibit him from commenting on the case or its fact pattern in any fashion and from attempting to monetize his prosecution in any form. His actions threaten the ability of the state to prosecute the case fairly and without outside influence, and potentially threaten the safety of those involved in the prosecution. And it says the date and time of the hearing. These are the prosecutor's information. This is a public document, by the way, electronically filed. That's the file stamp. It's public record. And what is interesting is the only legal argument that is cited is this paragraph and then a couple of sentences right there. That is all that they put in this motion to support this. This is so deficient as a legal pleading, as you are required in any motion seeking relief, that you need to have a proper memorandum of law, legal precedent citing the legal basis to assert the motion, and again, the relief for which you're seeking. This is so thinly veiled. I mean, this is absurd. All right, now let's take a look at the case. Carruthers, we're going to go into detail and we're going to learn a lot about gag orders and free speech law for criminal defendants and participants in a criminal case. Okay, now let's take a look at State of Tennessee versus Tony V. Carruthers and James Montgomery. It's known as the Carruthers case. This is the primary case that comes up immediately when you do any kind of search on the issue of gag orders in a Tennessee criminal defense matter. So again, to explain what occurred, let's talk about this case, the overview. This involved a pro se defendant who had represented himself. In the case, the court did make an issue of that, the fact that he didn't have an attorney, but the holding is still pretty consistent regardless of whether you have an attorney or not. This, just a little background here, pro se defendant and represented co-defendant were each convicted of 3 counts of first-degree murder, 3 counts of especially aggravated kidnapping, and 1 count of especially aggravated robbery. And based on extensive evidence, the jury found numerous aggravating circumstances and imposed the death penalty. On direct appeal, the appeals court affirmed both defendants and co-defendants' convictions and sentences. And pursuant to Tennessee Code 39-13-206, the Supreme Court of Tennessee reviewed the record and affirmed the judgment against the defendant, holding that defendant, by his extreme and egregious misconduct, implicitly waived and forfeited his right to counsel under the U.S. Constitution. The appellate court further held, under its proportionality review of the capital cases, that the sentences of death upon pro se defendant were not excessive, were imposed in an arbitrary manner. However, the appellate court reversed the co-defendant's convictions and remanded for a new trial, holding that the trial court's failure to grant a severance resulted in prejudicial error. This is just to kind of give some background about what this case was about, and that this is what, and again, the court here upheld the gag order, but stated that the trial court was in error, that it was overly broad. So while the technicality of upholding it, the court basically said the gag order was no good. So now let's go down and let's look at the legal analysis from the court on the issue of gag orders. All right, this is on the issuance of a gag order. Now, Carruthers next argues that the trial court committed reversible error by issuing a gag order, preventing him from speaking to the media. The trial court's order, issued about a month before the trial began, states, so this is the language of the gag order as I understand. The constitutions of the United States and the state of Tennessee guarantee defendant in all criminal cases due process of law and the right to a fair and impartial jury. It is the duty of the trial court to see that every defendant is afforded all his constitutional rights. In order to safeguard those rights, this court is of the opinion that the following rule is necessary to constitutionally guarantee an orderly and fair trial by an impartial jury. Therefore, this court orders the following. All lawyers participating in this case, including any defendants proceeding pro se, the assistants, staff, investigators, and employees of investigators, are forbidden to take part in interviews for publicity and for making extrajudicial statements about this case from the date until such time as a verdict is returned in this case in open court. Because of the gravity of this case, because of the long history of concerns for the personal safety of attorneys, litigants, and witnesses in this case, that is extremely key here. This was about violent individuals where apparently some threats or actual violence occurred. That part I'm not quite clear about, but it's clear what the scope and the context of this is. So again, because of the gravity of this case, because of the long history of concerns for the personal safety of attorneys, litigants, and witnesses in this case, because of the potential danger believed by this court to be very real and very present of undermining the integrity of the judicial system by, quote, trying the case in the media, end quote, and of sullying the jury pool, this court feels compelled to adopt the extraordinary pretrial measure. The prosecutor read this case. He knew what the context of the case was, but he's trying to rely upon this about a YouTuber who didn't pay sales tax on a car, involving nothing about violence, nothing about riot. He never said anything telling people to do anything inappropriate other than exercising their right to redress their grievances against a public body in a way that was professional, legal. He never told anybody to do anything inappropriate. But you trying to shut him up and prevent him from defending himself. I'm repeating myself, but this really struck me as a free speech attorney. So Carruthers challenged this disorder as violating his right to a fair trial, guaranteed by the 6th Amendment to the United States Constitution and Article 1, Section 9 of the Tennessee Constitution. Those specific citations there are involved about the right to a fair trial and speech. Now, Carruthers is correct to rely upon the Sixth Amendment. We note, however, that the United States Supreme Court has stated that, quote, a right to a fair trial, end quote, claim also implicates the Fifth and the 14th Amendment due process clauses. The Constitution guarantees a fair trial through the due process clauses, but it defines the basic elements of a fair trial largely through the several provisions of the Sixth Amendment. Nonetheless, numerous courts have referred simply to the Sixth Amendment right to fair trial in this context, and we will do the same. Carruthers also raises First Amendment concerns, which is understandable given that gag orders exhibit the characteristics of prior restraint. Now, a prior restraint is where the government would, in essence, tell a person or an entity not to speak, publish, communicate, or such other about an issue before a certain event or a time period or so forth. So here they're trying to establish prior restraint, and that is a common term used in free speech. Now, noting a substantial difference between a restraint on the press and a restraint on trial participants, and that's a key factor they talked about in this case. Yet the crux of Carruthers' argument on appeal is that his defense was inhibited because he could not respond to the media's coverage of the trial. He could do nothing to alter the jurors' preconceptions about the case gained from their exposure to news reports. Carruthers also argues that his inability to speak to the press may have prevented potential witnesses from coming forward to his defense. Now, I'm kind of known for speaking to the media a little bit, but I always try to limit my comments to what is in the public record, what is in the complaint and the lawsuit, which is public record. And I often cite that, sure, a purpose of it is that because there may be witnesses out there in the public that may have information about the case and to communicate with us, and that's completely appropriate. Properly stated, then, is an argument. It asserts that the gag order interfered with his right to a fair trial. That's an interesting argument he raises, because usually we would just think about the First Amendment part. To the extent Carruthers' brief raises a First Amendment claim, however, we find it moot. By its own terms, the trial court's order ceased to exist upon the return of the verdict. All right. Of course, since a gag order is by definition a restriction on speech, our review of Carruthers' Sixth Amendment claim demands consideration of First Amendment principles. As is clear from the case law discussed below, the proper standard for governing the validity of gag orders explicitly incorporates these principles, as we do in our analysis. So here are several of the factors that were considered. The Court of Criminal Appeals rejected Carruthers' arguments and upheld the gag order in its entirety. Now, that was the lower court before the Tennessee Supreme Court, which, again, upheld the gag order, but it said it was overly broad. But the lower court before this court opinion that we're talking about, it upheld the gag order in its entirety. But what it cited was that the following circumstances were considered as reasons for issuing the gag order. And I can understand. I mean, these are pretty serious facts. Numerous threats to attorneys, the death of one of the co-defendants, the highly charged emotional climate of the trial, the courtroom was guarded by SWAT team members, the gunning down of a deputy jailer in his driveway, which the trial judge thought was related to the case, the fleeing of one witness after reading about the case in the newspaper, and the statements of the two witnesses who had already testified that Defendant Montgomery threatened to kill them if they talked about the case. I mean, that's how serious of the facts were for the court to say, hey, we're going to issue a gag order. But then even under these facts, the Supreme Court of Tennessee said, no, it's overly broad on these facts. But yet the prosecutor in Williamson County went in and wanted a gag order on a YouTuber about sales tax revenue. Again, I keep reinforcing that to explain how the absurdity of that motion, and the absurdity is self-evident in the affirmance of the pleading by the fact that he couldn't even cite any law to support the motion and the relief for which he was seeking, other than just citing this case and then two or three sentences. All right. So again, the court says here that we agree with the Criminal Court of Appeals judgment that under these circumstances, a gag order was proper. We hold, however, that under the constitutional standards discussed below, the scope of that order was too broad. Nevertheless, given the circumstances of this case, the error is harmless. Now let's get into some of the constitutional law about this. Numerous courts have recognized the correct standard by which to evaluate the constitutionality of gag orders depends upon who is being restrained. The press or trial participants? There's an attorney for a very large firm in Nashville who represents media throughout the state of Tennessee and I believe in other states. And I've spoken with him before and had some interesting conversations really about what he does, because I was always curious about what he had done and the different types of things that they filed. And I'll give an example. For example, I'll give an example of a case. I think he's on it, but it may be another firm. Like right now, we have this 5-foot buffer rule that some of the states in the Southeast are trying to file for how far let's say a YouTuber or even a member of the press, how far back they have to be at a minimum distance from a police officer when there's like on scene of maybe it's a traffic stop or a criminal scene, etc. And a lot of the press is saying that that's unconstitutional and that interferes with their right, again, the rights of the press, right to speech, etc. And they'll hire an attorney like him and to sue the particular law enforcement agency, or maybe sue state of Tennessee, etc., on trying to overturn that law. So right here, we talk about the distinction of the press or trial participants. If the gag order is directed to the press, the constitutional standard is very stringent. So you would think by reading that they try to hold that there's a higher standard for the press. Carruthers' appeals before this court, however, concerned the trial court's gag order directed to him, a defendant representing him at trial. So here we're going to talk about here in a moment, talking about the difference between, is there a higher standard for the press or an individual? As the United States Court of Appeals for the Fifth Circuit has recently determined, and of course this is a 2000 case now when we talk about recent, I'm just reciting the case. The federal circuits are split as to the correct constitutional standard governing gag orders on trial participants. This is a 2000 opinion. For example, the Sixth Circuit, which is where that's Tennessee, Kentucky, Michigan, Ohio, the Sixth Circuit has held that gag orders on trial participants must meet the, quote, clear and present danger, end quote, test for free speech cases. And then there's a quote here, we see no legitimate reasons for a lower standard for individuals as compared to the press, and I agree. Applying, quote, a serious and imminent threat test. And that's apparently what this court was to decide, is which test to apply in these gag order cases. So here, then it talks about another conflict in the federal circuits. In contrast, the Second, Fourth, and 10th circuits analyze the validity of gag orders on trial participants under the less stringent standard of whether the participants' comments present, quote, a reasonable likelihood, end quote, of prejudicing a fair trial. That is a much lower standard. And usually it's when you have conflicts in the federal circuits like this on a particular issue, that's how you get a case to the U.S. Supreme Court, because we have to resolve the conflict amongst the federal circuits to have uniformity nationally. Without deciding whether to adopt the reasonable likelihood standard, the Fifth Circuit determined that the clear and present danger test was not required and analyzed the case before it under a substantial likelihood test. They talk about how this court has upheld restraints. Again, that's restraints on free speech on trial participants, an order restraining counsel from talking with the public or media about the facts of a case, but we've never discussed the underlying constitutional issues. And that's why this case is so key. We therefore decide this issue based on our own interpretation of the United States Supreme Court precedent and the Tennessee Constitution, with guidance from the federal circuit courts. The Tennessee Supreme Court here doesn't have to go by federal court opinions as actual authority. They can use it as what we call persuasive authority. Now, the Tennessee Supreme Court does have to go by the Constitution and the opinions of the U.S. Supreme Court for direct authority or actual authority. We have to listen to what they say, meaning persuasive authority would be, well, we can listen to you and maybe you persuade us or you don't. All right, we note that the Court of Criminal Appeals opinion emphasized that the twist in this case, however, is that Carruthers was representing himself during trial. So that was a key fact here. Although this fact is relevant in applying the constitutional standard to determine whether Carruthers' right to a fair trial was breached, our review of the case law indicates that the constitutional standard is the same regardless of which trial participant is restrained. So here, they went through some rationale, which is beyond the scope of this video, and they quote here, we conclude that for the purposes of the constitutional right to a fair trial, Gentile's rationale applies to all trial participants, meaning that the more stringent, clear, and present danger test is not required. Having decided that the clear and present danger test is not constitutionally mandated, we must now decide which test to adopt, the substantial likelihood of prejudice test, or as some courts have employed, the reasonable likelihood test. And as noted, Gentile held only that the substantial likelihood test was constitutional, not that it was required. Nonetheless, we conclude under both the state and federal constitutions that the substantial likelihood test strikes a constitutionally permissible balance between the free speech rights of trial participants, the Sixth Amendment right of defendants to a fair trial, and the state's interest in a fair trial. Accordingly, we hold that a trial court may constitutionally restrict extrajudicial comments by trial participants, including lawyers, parties, and witnesses, when the trial court determines that those comments pose a substantial likelihood of prejudicing a fair trial. Now, under this constitutional standard, we hold that the trial court was justified in imposing a gag order on Carruthers. At trial, this case garnered a significant amount of media coverage, raising the concerns expressed to Shepard. Court goes on to looks at the facts to justify it. Now, let's talk about a little more about the legal language about gag orders. Before a gag order can be entered, however, the case law suggests that a trial court should consider reasonable alternative measures that would ensure a fair trial without restricting speech. In the context of restraints on the press, the United States Supreme Court has specifically held that a trial court should consider such measures. These measures include a change of trial venue, postponement of the trial to allow public attention to subside, searching questions of prospective jurors, and emphatic instructions to the jurors to decide the case on the evidence. Well, here you saw the prosecutor in his motion just went all the way to the extreme and asked the court to have Cody Detwiler keep his mouth shut and not say anything or not publish anything. He didn't put in some lesser restrictive alternatives in his motion. Although it is not clear whether the need to consider alternatives is also necessary in the context of restraints on trial participants, some federal circuit courts have assumed so, and the trial judge considered several of the alternatives. The trial court found that neither a change of venue nor a continuance was practical because the case was several years old and one attempt to try the case had already been made. The court appropriately gave attention to voir dire and jury instructions, but determined that these narratives alone were insufficient. The trial court reasonably concluded that a gag order would be effective. Finally, we note that the alternatives mentioned above are not free of cost to the judicial system. Even if a fair trial can ultimately be ensured through voir dire, a change of venue, or some other device, these measures entail serious costs to the system. Extensive voir dire may not be able to filter out all of the effects of pre-trial publicity, and with increasingly widespread media coverage of criminal trials, a change in venue may not suffice to undo the effects of statements such as those made by the petitioner. So, having decided that the trial court did not err in issuing the gag order, the final issue is to the scope of the order. That again, what are the specific terms and the conditions? As discussed above, Carruthers' argument on appeal is properly construed as a right to a fair trial claim rather than a First Amendment claim. Nevertheless, a gag order by definition restricts speech. In determining whether a gag order is appropriate, therefore, a court must be mindful that government may not regulate expression in such a manner that a substantial portion of the burden on speech does not serve to advance its goals. The limitation on speech must be no greater than is necessary or essential to the protection of the particular governmental interest involved. Well, that's where the prosecutor here failed with the motion. He went all the way to the extreme, and he asked for relief that was certainly greater than what was essential. On its face, the trial court's order has no exceptions or limitations. It prohibited the defendants and their attorneys from making any comments to the press about the case. This gag order is considerably broader than any upheld in the cases discussed above. Gentile, though not a gag order case, involved a limitation on attorney speech, which prohibited only statements substantially likely to prejudice the adjudication of the case. Given the history of this trial, we certainly understand why the trial court crafted such a broad order. Indeed, in certain cases, as where a defendant takes advantage of a limited gag order or fails to comply with it, an order of such breadth may be justified. Nonetheless, here's the key. We hold that the initial gag orders on trial participants should ordinarily contain the exceptions found in the Brown order and allow trial participants to make general statements asserting innocence, commenting on the nature of the allegation or defense, and discussing matters of public record. We find the trial court's failure to include these exceptions in the gag order was harmless error. We failed to see how limited statements made by Carruthers to the media about his innocence, allegations, or defenses, or matters in the public record would have altered the result of the trial. We do not think that allowing Carruthers to make such statements would have furthered the goal of finding an impartial jury, nor do we think it probable that any new witnesses would have come forward. So right now, it is my understanding is that this morning, based upon the limited information that I can glean from an article, is that the court may have issued a gag order very limited in scope. And so I believe that he won today. And as soon as I can get more detail on that, I'm going to do a follow-up video on this. So take that with a grain of salt, what I'm saying. I don't have all the details, but it appears that it was very limited in scope. And I'm going to do, again, as I said, a follow-up video. Please click like, share, and subscribe. Have a great day.